Well, the Federal High Court in Abuja is asking the Senate to consider recalling the senator representing Kogi Central, Natasha Akpoti-Uduaghan. Natasha was suspended in March by the Senate for 6 months for alleged gross misconduct, days after a face-off with Senate President Godswill Akpabio over a change of seating arrangement in the chambers during plenary. In a ruling, Justice Binta Nyako described as excessive the 6-month suspension that was slammed on the lawmaker by the Senate. The court faulted the provision of Chapter 8 of the Senate Standing Rules, as well as Section 14 of the Legislative Houses, Powers and Privileges Act, declaring both as overreaching. The court stressed that the two legislations failed to specify the maximum period that a serving lawmaker could be suspended from office. According to the court, since lawmakers have a total of 181 days to sit in every legislative circle, suspending a lawmaker for roughly that same length of time effectively silences the voice of an entire constituency. Well, different interpretations have trailed Friday's judgment by Justice Binta Nyako of the Federal High Court on the matter between Senator Natasha Akpoti-Uduaghan and the Nigerian senator over her 6-month suspension. Although the court declared that her 6-month suspension was excessive, many have argued that the court fell short of ordering that the Kogi Central senator be recalled, while some others think otherwise. Well, this confusion has given rise to some fundamental questions. What exactly is the interpretation of this judgment? Can the court compel the Senate to recall a senator that was suspended for a period of time the court termed excessive? Can Senator Akpoti-Uduaghan resume on her own, relying on the decision of the court that our suspension was excessive? Let's get more clarity on this from Frank Tietie, lawyer and Arise News analyst. Glad to have you join.
Thank you. My pleasure.
Good. Wonderful. So, first off, what exactly is the interpretation of this judgment?
Well, it's a sad thing that people have to sit in interpretation or in judgment over judgment. It shouldn't be that way. The reason why courts exist is to actually resolve conflicts, to cure doubts, and when there are ambiguities. So when people approach the courts and because they are quite on some form of uncertainties, they should come out, with some express, clear direction that the court has given. In this case, there seems to be more confusion, and that's another failure on the part of the court. It shouldn't be so. But again, we can't be conclusive because we're talking about a judgment that is yet to be published, that is yet to be released by the court. As we speak, I doubt if any person has a copy of that judgment. Again, that is not the best because we have a tradition in some of the courts, like the Federal Capital Territory Court, courts in the Federal Capital Territory, particularly high courts. They are able to give you the copy of a judgment immediately after it has been read by the judge. Another court that does that as a matter of standard is the National Industrial Court. The Federal High Court shouldn't fall short of that, so leaving room for these kind of uncertainties. Nobody should actually be making any interpretation now because they haven't had a copy of the judgment. However, what is clear is that people are speaking to a media icon, or rather I would say a media consultant. He said he was referring to the judgment as being advisory, and I said, look, this is not an international court and that is giving a judgment that is advising one party, which is usually a state. This court is supposed to make express directives, but from the media reports, it's clear that the court is does not agree with the length of judgment. I mean, the length of suspension. It's not different from what we have said before, because the centrality of this issue is not really Senator Natasha Akpoti, but the Constitution of the Federal Republic of Nigeria that recognizes the right of a certain persons to be represented in the Nigerian Senate. Would that right be extinguished because of issues that have to do with Apologies to who? Would the Nigerian state, you know, for the sake of not having an apology given to it, deprive a certain people of Kogi Central of the, you know, legitimate representation in the Senate? So I think we are stretching this Senator Natasha's issue to the detriment of democratic values. We are now saying that a people have now been deprived, because the issue of political representation is actually a right. So I doubt whether these issues could have actually been resolved without the core interest of the people of Kogi Central. The judgment also, the reportage of this judgment has been overshadowed by the issues that have to do with the contempt against Senator Natasha. It's interesting that, you know, dealing with issues of contempt, because contempt is actually a criminal offense that should be tried, separately from the case, from the substantive case. Now, one would have expected that the originating summons would have been dealt with in clear terms, and the reliefs that have been sought by Senator Natasha would have been dealt with serially, so that we know what the court has provided for. At no time, at no material time, did any person contemplate the powers of the Nigerian Senate to apply some measure of discipline.
Now that's the next question I want to ask you. Can the court compel the Senate, knowing that you have separation of powers, to recall a senator that was suspended for a period of time based on its own rules?
Oh, yes, indeed. We're talking about the Nigerian Constitution here, the highest law upon which every authority and persons in the Federal Republic of Nigeria must comply to. And when especially you're dealing with issues that have to do with rights of human beings, of peoples, the courts under Section 6 of the Constitution has such powers to give directives that must be immediately obeyed by all such authorities, which include the National Assembly. It doesn't matter whether the principle of separation of powers does not mean that the courts are completely, emasculated from exercising any authority on the other arms of government, like the legislature, that's the National Assembly, or the executive, referring to the presidency, or the various governors and the governments of all the state governments. The courts have all such powers, provided it is making such decisions according to law. In this case, yes, the court has the power to compel. And again, no, it's not about precedents. You see, the standing rule is that whenever a court in Nigeria, no matter how low or high the court is, makes a pronouncement, it is automatically obeyed. So we are facing a dysfunctionality that has existed for so long. That's why we ever question whether or not to obey an order that has
Does it mean that the senators or the lawmakers do not understand where to draw the line between obeying the court and their rules? They're lawmakers.
You see, in this case, we're talking about the personality of the Senate president and another particular senator, Senator Natasha Akpoti-Uduaghan. Now, one senator is more powerful than the other because he is the Senate president. Now, there is a way when political power is exercised that has a tendency of always disregarding rights. That's why powers are delimited, powers are contained, are restricted. And when there are violations, persons who feel that they have been affected by the abuse of any form of political power can now approach the court, and the court straightens, defines rights, make a determination of what the issues are, and then it's able to give clear directives. And in this case, we're talking about determining rights, we're determining interest, and then the principle, and then giving justice to the person who has approached it.
All right. Well, This question I'm going to ask you now is because you said nobody has seen the judgment really, so I don't know whether it's putting the cart before the horse, but all the same, let me ask you, can Natasha rely on the decision of the court to go back to the Senate?
I doubt.
Can she, okay.
Because the court...
Can she appeal?
Oh yes, there are very many reasons. For example, if the judgment has been quite nebulous to this extent, and then she has also suffered some measure of humiliation by the fact that she was fined by way of contempt charges, for an innuendo that she made. Those are issues that have not overshadowed the real issues that Nigerians are interested in.
But she can't go back to the Senate.
She cannot proceed in disorder. The Nigerian National Assembly, the Nigerian Senate operates by a certain order. By now, we expect the Senate to issue a statement with respect to what has happened with respect to the judgment. Unfortunately, it cannot do so because the court has failed to provide the certainty that is required by even starting with the judgment itself for the public to see. As we speak, we have conflicting reports by media houses.
Senate says if she apologizes, and they will sit and reconsider.
No, that's dangerous. Very, very dangerous. You are now subjecting democratic norms in our country to an apology to who? To certain men,
to
a certain
to
man.
The Senate.
No.
To the
how?
Legislative body.
How does it now sound that you are depriving the rights?
But the apology is ordered by the court.
Of course, the apology for what? For the contempt. For issuing certain statements. And I consider that as an innuendo. And when you make innuendo, and that's what even makes it more confusing. And that's what makes it very defeatist. That they have now left the substantive issues. They're now going to deal with issues of whether or not a certain satirical statement that was published in Facebook amounts to anything.
No, but she was asked not to make comments because it was sub judice, so don't make comments.
So you see what we are talking about? So we are not arguing whether or not those comments are directly related to the Senate President or not, or whether they have any value
to the case.
Whether they have any value to the case. But we are talking about someone, are you now also depriving her of the right to be poetic, to write a satirical statement about anything? You say these are prevarications. We are running away from the real issues. We need to make some progress, and the courts have not really helped with this kind of uncertainty that we have had in this matter.
Well, I heard that in law, innuendos are good as directives or something.
No. You see, it depends how direct they are.
We'll leave it there. Thank you so much, Frank Tietie. Always ready to fire on if we let you go on. Thank you for being on Arise.
My pleasure.
Newsnight.